Hello everyone, welcome to Court with Krissy. My sister's first boyfriend got sentenced today, back to prison after his 33rd conviction. But instead of that, I find this more interesting. It's the state of Michigan versus Attorney Karen's client, Mr. Talisman, and it's his jury trial. Today we're kicking it off with the opening statements and the first witness. And a little disclaimer, I have a full-time job. My daughter just graduated. This weekend is her open house. This 2-day trial might take 10. Just stick with me. We'll get through it together. I hope you like it. Court with Krissy is now in session.
I'm just going to be going by case number regarding these charges, and again, they'll be all provided for you in written form as well. But beginning in the first case, that is 247158FH. In count one, the defendant is charged with aggravated stalking. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed 2 or more willful, separate, and non-continuous acts of unconsented contact with Shauna Lavalette. Unconsented contact means that the defendant initiated or continued contact within sight of Shauna Lavalette, approaching Shauna Lavalette in public or on private property, appearing at Shauna Lavalette's workplace or home, entering or remaining on property owned, leased, or occupied by Shauna Lavalette, contacting Shauna Lavalette by telephone, sending electronic communication, or mail to Shauna Lavalette, and or placing an object on or delivering an object to property owned, leased, or occupied by Shauna Lavalette. Second, that the contact would cause a reasonable person, or reasonable individual, that is, to suffer emotional distress. Third, that the contact caused Shauna Lavalette to suffer emotional distress. Fourth, that the contact would cause a reasonable individual to feel terrorized, frightened, intimidated, threatened, harassed, or molested. Fifth, that the contact caused Shauna Lavalette to feel terrorized, frightened, intimidated, threatened, harassed, or molested. Sixth, at least one act of unconsented contact was committed in violation of a restraining order of which the defendant had actual notice. In the same case, which would be count 2, the defendant is charged with using a computer to commit the crime of aggravated stalking. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed the crime of aggravated stalking, which has been defined for you. It is not necessary, however, that anyone be convicted of that crime. Second, that the defendant intentionally used a computer to commit that crime. Computer means any connected, directly interoperable, or interactive device, equipment, or facility that uses a computer program or other instructions to perform specific operations, including logical, arithmetic, or memory functions with or on computer data or a computer program, and that can store, retrieve, alter, or communicate the results of the operations to a person, computer program, computer system, or computer network. In this first file, the prosecutor in this case must also prove beyond a reasonable doubt that the crime occurred on or about July 2nd through July 3rd, 2024 in the city of Van Nuys, County of Huron. In the second file, which would be 7178, the defendant is charged with, in count 1, with home invasion in the first degree. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant entered a dwelling without permission. It does not matter whether the defendant got his entire body inside. If the defendant put any part of his body into the dwelling without permission, that is enough to count as an entry. Second, that when the defendant entered, was present in, or was leaving the dwelling, he committed the offense of assault with intent to do great bodily harm less than murder. Third, that when the defendant entered, was present in, or was leaving the dwelling, either of the following circumstances existed. He was armed with a dangerous weapon, and or another person was lawfully present in the dwelling. On that same file, in count 2, the defendant is charged with the crime of assault with intent to do great bodily harm less than murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant tried to physically injure another person. Second, that at the time of the assault, the defendant had the ability to cause an injury, or at least believed that he had the ability. Third, that the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was an injury that is, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. In count 3 of the same file, the defendant is charged with the crime of interfering with an electronic communication. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant prevented, obstructed, or delayed by any means the sending of an authorized communication through a telephone line or any electronic medium of communication. It does not matter whether the communication was actually sent or received. Second, that the defendant did this willfully and maliciously. This means that the defendant did the act on purpose and with the intent to prevent, obstruct, or delay the communication. Prosecution in this case must also prove beyond a reasonable doubt that the crime occurred on or about July 3rd, 2024 in the township of Austin, Sanilac County, Michigan. In the final file, 7184, defendant is charged in count 1 with home invasion in the second degree. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant entered a dwelling without permission. It does not matter whether the defendant got his entire body inside. If the defendant put any part of his body into the dwelling without permission, that is enough to count as an entry. Second, that when the defendant entered, was present in, or was leaving the dwelling, he committed the offense of unlawfully accessing a computer system. In count 2 of that same file, the defendant is charged with the crime of unlawfully accessing a computer system. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant accessed a computer or computer program or computer system. Second, that the defendant did so intentionally. Third, that the defendant did so without valid authorization. Fourth, that the defendant did so to use the services of the computer or computer program or computer system. And when deciding whether the defendant acted without valid authorization to access the computer or computer program or computer system, you may, but you do not have to infer that he did not have authorization if the defendant accessed the computer system, the computer intentionally, unless written or verbal authorization was given by the owner, the system operator, or someone acting on his or her behalf, or the computer program, or computer system the defendant accessed had password protections that included notice that would lead a reasonable person to believe that anyone was permitted access, or the defendant got access without using a set of instructions, a code, or a computer program that was designed to bypass or get around password protections. The prosecutor still bears the burden of proving all of the elements beyond a reasonable doubt. The prosecutor in this case must also prove beyond a reasonable doubt that this crime or these crimes occurred on or about July 2nd through July 3rd, 2024 in the city of Van Nuys, County of Huron. As I stated, the person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes his, or she may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer, to make their closing arguments. And just like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to the case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide the case. Your responsibility as jurors is to decide what the facts of the case are. This is your job, no one else's. You must think about all the evidence, all the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Now, part of your job in deciding what the facts of this case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. Now, in deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on the witness's disability, race, national origin, ethnicity, gender identity, sexual orientation, religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge their testimony? Does the witness have any bias or prejudice or any personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in this case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask are not evidence, only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. During the course of this trial, I may ask some of the witnesses questions myself. Now note, these questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. As I stated before and one here, if you cannot hear or understand that is said, anything that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately and let the court know. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on those objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while in the jury room, I may have to take care of other matters that have nothing to do with this case. I'd ask you please pay no attention to those interruptions. But if it's something not related to the case, I try to focus on this trial because your time is extremely important. Parties would agree, I hope. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with other jurors until the time comes for you to decide this case. When it is time for you to decide this case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room, and only when all the jurors are there. And I've hinted at this in voir dire, or the conclusion of voir dire. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals, even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss this case with you or in your presence, tell that person to stop and explain that you are a juror. You are not allowed to discuss the case. If they persist or continue, just leave. Report the incident to court staff as soon as you return to court. When the trial is over, these restrictions no longer apply, and when the trial is over, you may, if you wish, discuss the case with anyone. The restrictions I'm about to describe are meant to ensure that the parties get a fair trial in our judicial system. It is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you consider must meet certain standards. Example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these same safeguards, it could give you incorrect or misleading information that might unfairly favor one side or the other. These restrictions start now and continue until I discharge you from your jury service. It is your duty as a juror to decide the case based solely on the evidence you see and hear in the courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether newspaper, radio, internet, or social media platforms. Excuse me. You also must not research any aspect of the case during the trial. This means research using cell phones, computers, or other electronic devices to search the internet, as well as research with traditional sources, sadly, that we don't use anymore. Dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using internet, cell phones, computers, or other electronic devices. You must not visit the scene of any event at issue in the trial. It is necessary for you to view or visit the scene. Court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cell phones or social media. This means that even if you're not discussing the case with someone else, you may not post any information about the case in social media, websites, or in any other manner. If you discover that a juror has violated these instructions, please report it to the court staff. And they are. Thank you. Court staff is always on top of this. You may take notes during the trial if you wish to. However, you do not have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. So very simply, if you do take notes during the course of this trial, and we take a short break, just simply take your notepad, place it upside down on your chair. That ensures that no one will examine your notes. Your notes will not be examined by anyone, and when your jury service concludes, these notes will be collected and destroyed. Possible penalties should not influence your decision if you find the defendant guilty. It is the duty of the judge to fix the penalty within the limits provided by law. As always, I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law to apply. That applies in this case. You should consider all my instructions as a connected series. Taken all together, they are the law that you must follow. After my final instructions, you will then go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. Probably the most important part of these instructions so far, beside the elements and all the other items you have to consider, it is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, public opinion influence your decision. Now, each of us may have biases or perceptions about other people based on stereotypes. We may be fully aware of some of our biases, though we do not express them. We may not be fully aware of some of our biases, other biases, I'm sorry. Take the time you need to test what might be automatic or instinctive judgments and reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about the case individually, but you should do so only after listening to and considering the opinions of other jurors who may have different backgrounds and perspectives from yours. That concludes all my initial instructions in this case. It is now time for opening statements. Mr. Bahani, you may proceed.
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Alexander Pahani, and I'm an assistant prosecuting attorney here in Huron County. And along with prosecuting attorney Timothy J. Rukowski, we'll be presenting the case to you today on behalf of the people of the state of Michigan. So before we begin, I would just like to express our thanks to you for honoring your jury's summons, because as the judge pointed out to you throughout the day this morning, jury service really is the most important cornerstone of our system of justice. The Constitution guarantees everyone accused of a crime, and to the people of the state of Michigan as well, a fair trial by an unbiased jury, and that's you. And so we appreciate your honoring that summons and being here today. Now, ladies and gentlemen, it's such an important factor because you, individuals here today, are the finders of fact. In other words, you have to decide when we present this evidence to you, what happened on the date of July 2nd and July 3rd, 2024 in Austin Township, Sanilac County, and the city of Bad Axe, Huron County. You will hear from many witnesses today, and as the court pointed out to you, you will have to determine their credibility. You will have to decide what you believe and what you may not believe. And that's why your job is so important, because your decision is final. You are the only ones who can determine the facts of this case as to what happened over the course of those 2 days. So your job is the most important one in this court. Now, as the court indicated, the opening statement is kind of an idea of what you're going to see today, laying out our theory of the case. So what you're going to hear first is from the Sanilac County 911 Central Communications. You're going to hear a witness, and you're going to hear a 911 call. And that's what kind of got this whole thing started, because on the evening of July 2nd, 2024, 911 call comes into Sanilac County Central Dispatch about a home invasion in Austin Township in Sanilac County, which is within 1 mile of the Huron County line. You may be wondering, and it might have crossed your mind today, why are we listening to a case that took place in Sanilac County? Anything that happens within 1 mile of a county line, in this case, 1 mile of the Huron County line, can be tried in that county. So while this did occur in Sanilac County, and we have to prove that to you beyond a reasonable doubt, the case is being tried here, and I'll explain a little bit more about why that is in just a minute. You'll hear this call for service from the Sanilac County 911 dispatch. And basically what you hear, what we expect you to hear, is that somebody showed up at this individual's house. His name is Dan Stevens. He was at home that night watching a movie with his friend. And all of a sudden, the defendant showed up. And the defendant proceeded to bust into the house, assault Mr. Stevens, and pretty much destroy the house and the entire proceeding. So, with the 911 call, Sanilac County Sheriff's Office gets dispatched, and they're racing to the scene, and you're going to hear from Deputy Matthew Washington. He's our officer in charge today, and he was the first deputy that got out to the scene. And you'll hear his testimony as to what he saw on that day, and you'll also get to see video footage from his body-worn camera. So you get to see it just as Deputy Washington did as soon as he walked up to the house and started to figure out what's going on. As he's walking into a house that looks pretty much like it's been destroyed. It's Deputy Washington's job to figure that out, and you'll hear his testimony. And then you'll hear from Deputy Chad Schmidt, who's also with the Sanilac County Sheriff's Office, and he was the next responding deputy. And so after the scene is secure and after Deputy Schmidt gets there, they start their investigation. And Deputy Schmidt takes quite a few pictures of the scene. You'll get to see those pictures. And you'll also get to see Deputy Schmidt's body-worn camera. And you get to see it from his perspective as soon as he arrived. Now, you'll also get to hear from the homeowner, Daniel Stevens. And we expect that he'll testify that he was hanging out with his friend, watching a movie, having a couple of drinks, and then all of a sudden, Mr. Talisman shows up. And Mr. Talisman is not there just to pay a visit, because the friend of Mr. Stevens happens to be Mr. Talisman's ex-girlfriend. And so that's where the problems sort of start. Mr. Talisman forces his way into the house and assaults Mr. Stevens. Meanwhile, his ex-girlfriend, who you'll also hear from, her name is Shanna Laviolette. She's hiding in the closet because these two men are fighting all throughout the house. And as I said, you'll see pictures of the aftermath. And Shanna is attempting to call 911, but Mr. Talisman is preventing her from doing so. She can't call for help, not until he leaves anyway. And he doesn't leave until his work there is done, until he lays out Mr. Stevens, and then he takes off. And we expect the testimony from both of those witnesses will reflect the same. Now, you'll also hear from Detective Sergeant Joshua Horst. He's the detective for the Sanilac County Sheriff's Department. And later on, he interviews Mr. Talisman and gets his side of the story. And luckily, those interviews are also recorded. And you'll get to see that. You see the interview just as Detective Sergeant Horst asks questions, and you'll get to see Mr. Talisman's responses. And you will find that those responses are not consistent with anyone else's. Now, you'll also hear from Dr. Bradley Blaker. He's an emergency room physician here at McLaren Thumb Region Hospital, because in the aftermath of the assault that took place down in Sanilac County, Daniel Stevens was transported by EMS to the closest facility, and that's McLaren Thumb Region. And you'll hear Dr. Blaker tell you about what he saw when Mr. Stevens presented to the emergency department and what he had to do next. We expect that he will testify that he transferred Mr. Stevens out to McLaren Lapeer for a higher level of care, because as you may or may not be aware, our hospital here in Bad Axe doesn't have a lot of specialized care. And if your injuries are to a certain extent, or your illness is to a certain extent, you're often transferred out to a higher level hospital like McLaren Lapeer. And that's what Dr. Blaker, we expect, will testify to today. Now, I told you I was going to loop back to how does Sanilac County and Huron County tie into one another? Well, it turns out Mr. Talisman didn't just show up at random at Mr. Stevens' house that night to confront Mr. Stevens and his girlfriend. There was quite a bit of a chain of events that, through investigation, were able to determine exactly how he knew where Miss Laviolette was that evening. And that's where you'll hear testimony from both Sergeant Nate Flores and Officer Phil Deakins from the Bad Axe Police Department. Now, Sergeant Flores found Mr. Talisman the following morning after he had just left Miss Laviolette's house here in the city of Bad Axe. And that he believed to be a violation and a potential for aggravated stalking, because Sergeant Flores knew that there was a valid personal protection order in place between these two individuals. And so that's where Mr. Talisman ultimately had contact with the Bad Axe Police Department. And at that time, his cell phone was taken from him. Now, with your cell phone these days, there's a lot that the police are able to do. And that's where Officer Phil Deakins will testify, because he specializes in the forensic examination of electronic devices. And he will testify that leading up to the assault in Sanilac County, Mr. Talisman was at Miss Laviolette's house here in the city of Bad Axe. He will also testify, we expect, that Miss Laviolette was not at her house. And so that got Officer Deakins to investigate further. And he asked Miss Laviolette for her iPad because it was located in her house, and he wanted to do a forensic examination of that. And so we expect him to testify that when he did a forensic examination of the iPad, he found that someone had accessed that iPad. Someone had accessed her Facebook. Someone had accessed her Snapchat and found her location, because all of this happened just prior to the assault in Sanilac County. Now, who was that someone? Officer Deakins will testify that he was able to pull 960 location points off of Mr. Talisman's phone. And just prior to the assault in Sanilac County, despite what he told Detective Sergeant Horst in his interview, Mr. Talisman was in Shanna Laviolette's house, looking at her iPad, finding out where she was, and then driving down to Sanilac County and committing the home invasion. And so, again, Officer Deakins will take a relatively complex subject of how to examine forensic data off of cell phones, and he'll explain it to you, and he'll show you exactly where Mr. Talisman was from July 2nd all the way up to the time that Sergeant Flores found him in the city of Bad Axe after he had just left Miss Laviolette's home. Every data point from his house to Miss Laviolette's house, down to Sanilac County, and back to his house are all recorded. He'll explain that to you, and he'll show it to you. So, ladies and gentlemen, at the end of the day, what you will find is that this was not just a random attack, a random coincidence that Mr. Talisman just showed up at Mr. Stevens' house out of the blue, as he indicated that he did to Detective Sergeant Forrest. No, this was planned, ladies and gentlemen. He knew what he was doing. There weren't any coincidences. He was mad because his ex-girlfriend was hanging out with somebody else. And he committed a home invasion after he accessed someone else's computer system without any authorization to figure out where she was, all the while stalking her because there was a valid personal protection order in place, and then assaulted the man that she was hanging out with at his home. Ladies and gentlemen, at the end of the day, you will see that all of those elements that we talked about earlier today, the people will prove those beyond a reasonable doubt to you. And at the end of the day, your verdict on all of these counts will be guilty. I thank you for your time and attention over the next couple of days.
Ms. Roberts, would you like to provide your opening statement, or do you wish to reserve it?
I would like, Your Honor, I have a question for Mr. Cotton. Thank you, Your Honor.
You're welcome.
These the instruments appear sometimes create problems. Why she is today, how did we get here? You're going to hear two very different answers to the question, two different versions of the story. Shauna Lavalette and David Talisman have been in a dating relationship for about 3 years and lived together for about 4 months, and that was from December of 2023 through the end of March, or right around Easter of 2024. While they were dating and living together, Miss Lavalette was still seeing other men. And they often argued about this unfaithfulness. On April 15th, 2024, after she had left the home of Mr. Talisman, she obtained a personal protection order, or other known as a PPO, which is how I will continue to describe it. In that PPO, she claimed that there was physical abuse from David. And I suspect, or I expect, that she will tell you, that David will tell you, that there was never any physical abuse. The PPO states that David could not come within a certain amount of feet of Miss Lavalette. That meant no contact with her whatsoever, by phone, by text, by any kind of electric communication. Absolutely no physical contact. Shauna was included in that order, meaning that she was not to have any physical contact with Mr. Talisman. But that no contact order did not last very long. Within a very short period of time after she came to PPO, they were seeing each other again. And oftentimes it was at the initiation of Miss Lavalette. So she was seeing him, even though she had an order that said he could not see her. They would go to each other's house at least 1, 2, maybe 3 times a week. We believe the evidence will show. This continued through May and June of 2024. On July 2nd, the date of this incident, they had been in contact all day by phone and text. They had been together for the 3 days previous. July 2nd was on a Tuesday. Miss Lavalette and Mr. Talisman had been together on Saturday. They were together on Sunday, and they were together on Monday until she left for work on Tuesday, July 2nd. On July 2nd, Ms. Lavalette continued to talk with Mr. Talisman by phone and by text. On Saturday, before the incident, Mr. Talisman and Ms. Lavalette have taken Mr. Talisman's daughter because he had joint custody with his daughter Val. And oftentimes during the period after the PPO, both parties would take their children and do other things together. Now understand that this PPO that she had taken out was because she claimed she feared for her life, and that he had caused physical abuse to her during this time. and that she was afraid for her life. But she continued to see Mr. Talisman often at her initiation. They were both in violation of the PPO order. However, Shauna would not be arrested for one weekend because this order was against Mr. Talisman. David, because of the contact, even though she had often initiated it, would and could be and was arrested for violating the PPO. During the time that Ms. Lavalette and Mr. Talisman were together during these 2 months after the PPO, she was not afraid of him. They were, during this time, she was not afraid of any physical abuse. And all these times they were intimate. On the afternoon rather, of July 2nd, because they had been together for 3 days previous, Mr. Talisman thought everything was fine, and he thought he would surprise Miss Lavalette by coming over and taking her to a Chinese restaurant. I think it was China King dining. She wasn't home. So he went inside, as he often did. They had access to each other's house all the time. He would come into her house because she didn't have a key, and she would go into his house, of course, unannounced. But this was common practice during the relationship, even after the PPO. When he went inside, the iPad that she had in the house, which was not password protected, when it went off, he went to look through it. Again, no password protected. He showed that there was a message from a Daniel Stevens. And that the message said something about Miss Lavalette going over there. Of course, this is what we expect the evidence would show. When he saw that she was over at Mr. Stevens' house, he looked at it. And remember, they had access to all of the computers of each other. They even had access to the passwords on their cell phones. This permission did not stop during the time that they were together. They would also go, like I said, they were going to each other's house unannounced all the time. Mr. Talisman would often go into the house, and show into Miss Lavalette's house, and would often cook her dinner or clean her house, or just try to help her out. When he understood that Miss Lavalette was at Mr. Stevens' house, he was very upset. He was very hurt because he thought he had had a wonderful time for the past 2 days and didn't expect this to happen. He got into his truck, went over to Mr. Stevens' house, pulled up into the driveway, and on his way up to the front door, he stepped on the front porch, and all of a sudden, the door opened, and Mr. Stevens threw the first punch. Now, there is a big difference in size. Mr. Stevens is about 6 foot, give or take, an inch or two, and weighs around 230 pounds, or he did at the time. Mr. Talisman, however, was about 5'6". He was 21. Also at this time, Mr. Talisman had a long arm cast on his left arm because of an ATV accident. He had fractured his radius. He walked up to the door, and the first thing that happened was the storm door flew open, and Mr. Stevens punched him in the nose. Now, remember, there's a big difference in their height and their weight and their arm reach. Of course, the first thing that Mr. Talisman did was to defend himself. He was on the front porch. He was hit in the face, and he then returned the punch. And the fight ensued. During this time, Mr. Talisman fell into the house, and the fight went through the entire house. Chairs were turned over, things were broken. During this fight, Mr. Talisman and Mr. Stevens went through the bedroom door, knocking it off its hinges. Inside that bedroom was where Miss Marmalette was hiding. She had her iPhone and her glasses with her. When Mr. Talisman asked, "Where are you, Shawn?" She came out of the closet and let him know that she was there. She had a phone and her glasses in her hand. Of course, Mr. Talisman was very upset. And during this time when she came out of the closet, we really had to believe the evidence will show, the testimony will show, that Miss Marmalette took her phone and tried to get Mr. Talisman with it. At that point, he knocked it out of her hands. Mr. Stevens was taken to a clearing as was described by the prosecutor. When Mr. Talisman went to Mr. Stevens' house, he did not have a weapon. He did not intend to fight. He went there because he wanted to tell Miss Marmalette that he had had enough. He was done. This was way over the top. This wasn't the first time that she had been intimate with other people. And that's what almost all of their arguments were about. At no time Mr. Talisman ever physically abused Miss Marmalette. You need to listen very carefully to the evidence. Like I said, there are two different versions. It's up to you to decide to believe according to the evidence and according to the instructions that the judge gives you. You are the arbiters. You are the people who decide whether the defendant is guilty or not guilty. The job is very, very important. And all this respect what you do, that is mine. Every time you are there, out of the courtroom, into the courtroom, everyone stands up, respect to what you do and what you have to decide. I look forward to presenting the case to all of you.
Let me close that.
Yes. Wait, no, Members of the jury, in just a moment, we're going to take our lunch recess. However, based upon, any objection to disclosing the information presented by counsel? Ms. Roberts, any objection to the court describing why we're going to have a witness called rather than go to lunch?
No, sir.
Okay, appreciate it. The witness that is going to be called, according to the prosecution, was working all night, and the dispatcher is here based upon working in the evening. Assuming he'd be very tired, it'd be best to call that individual.
That's correct.
Fair assessment of the conversation, Ms. Roberts?
I'm sorry, Your Honor.
Was that a fair assessment of the conversation we had at sidebar?
Yes.
Okay, thank you. Call your witness. Miss, would you please step up to the witness stand just to my right? Before you have a seat, would you please raise your right hand facing the court?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes.
Please be seated. Just ask you to speak loudly and clearly. Ms. Burkowski, you may proceed.
Please state your name for the record and spell your last name for courtesy of the court reporter.
Barbara Lusky, Luskey.
Your occupation, ma'am.
911 dispatcher for San Juan County,
How long you worked for Sanilac County?
15 years now.
Worked last night?
I did.
Are you familiar with the record keeping process at Sanilac Central Dispatch?
Yes,
The calls that come into Sanilac Central Dispatch, are they recorded?
yes.
Is every one of them recorded?
Every single call is recorded.
So no matter what it is that gets called, barking dog, whatever it might be,
Barking dog, house fire, winds the fireworks, everything. Everything is recorded.
and is that done in the ordinary course of business of Central Dispatch?
Yes.
You said you worked there for how many years?
15 total.
Your Honor, may I approach?
You
I
may.
think it was 14 last year, but
14 as in,
literally.
you had testified previously in another
Correct.
hearing,
Now it's
correct?
15, yes.
May I approach, Your Honor?
Yes, you may.
Any would have been marked as people's proposed exhibit 74. You recognize that?
Yes,
You had a chance to review it?
yes.
What is that, ma'am?
That is a 911 call that came in for this case that we're dealing with today.
Back on July 2nd of
That's
2024, correct? That case involved, that call involves Mr. Talisman.
That's correct.
You had a chance to review that?
Yes,
Appear to be accurate.
yes.
Move to admit people's proposed exhibit 74.
Ms. Roberts?
No objection.
74 is it?
Request permission to play. Your Honor.
You may. While that's being set up, I will not require the court recording.
Sanilac 911, what's the address?
This is Karen with the transfer. Go ahead, ma'am. Thank you. What's your address again, please?
Okay, what's going on?
There was a break-in and assault by David Talisman.
Okay. Is he still there?
He is left.
Okay. Did he leave in a vehicle?
I'm assuming so. I did not see him pull up. I just saw him came in the house, and I hid in the closet, and the owner of the home, he beat him up and destroyed his house.
Okay, so the owner of the home assaulted David?
No, David assaulted the owner of the home.
Okay. So what is David's relationship to you?
He is my ex-boyfriend.
Okay. What is your name?
My name is Shanna Laviolette.
Spell the last name. Okay, so you don't know if he arrived in a vehicle or on foot or anything like that?
He drives an Impala. It's two-tone gold and black on the hood and the doors. I'm assuming that's what he drove in as.
Okay. Does anyone there need an ambulance?
Dan, who is the homeowner, doesn't remember anything happening, and he's bleeding.
Where is he bleeding from?
His face.
Do you have a clean dry cloth that you can put on that?
He's washing his face right now.
Okay. Are there any weapons in the home?
Are there any weapons in the home?
I don't think so.
No.
Okay. All right. I will get some people started your way.
Thank you.
You're welcome. Hey, if he comes back, if he shows back up at the house, call 911, okay?
Thank you.
Yep. And about how long ago did this happen? Was it right before you called 911?
Right before I called 911.
Okay. All right. If he shows back up, if you see him, call 911 back. Lock all the doors, okay?
Okay, thanks.
All right. You're welcome.
Lucky the call for service came out at military time 2117, correct?
Yes,
What is that in regular layman's terms?
2117, it would be 9:17 p.m.
From there, the dispatch, sheriff's deputy, correct?
That's correct.
The start of the call talks about a transfer. What does that mean?
We're so close to the Huron County line that the towers was hit, the 911 call hit off the Huron County line towers. Or the Northern Huron County line. And so when they get that, they transfer it to us. It happens frequently with anywhere in the United States when the lines are so close together.
So from that, it's not that the call gets answered here in Huron, it just automatically, because it's so close, transfer
Yeah,
from Huron.
you get it,
to
just
San
one click of a button, and they can transfer it over to the appropriate county.
Same would be said as if it was on the western side of Huron County between
Right.
Tuscola and
Tuscola, Lapeer, St. Clair County.
Thank you, ma'am. I have no further questions.
Ms. Roberts, cross-examination?
During the 15 years of working as a 911 operator, you've heard of a lot of people calling for various things, correct?
Yes. Yes.
And during that time, you probably had people call in who had interpreting.
Yes.
Are you able
Objection as to relevance.
Response? Objections relevant.
It's important to find out exactly the state of mind of the witness.
That would be speculation at that point. How would this person be able to speculate as to what a caller or somebody on the line, what's in their mind?
She would be able to discern whether someone was intoxicated, very intoxicated or not, because of years of experience, and that might make a difference in her responses.
And that may be the case, however, I believe that the testimony from this witness is she wasn't the dispatcher, she's the record keeper for Central Dispatch.
That's correct. So then you did not listen to her.
No, I did not, I did not, that's not my voice on there, that's my partner's voice. She took the original call. I'm the record keeper, so I listened to that call several times.
Objection sustained. Redirect.
No, Your Honor.
Please sit down.
May this witness be excused.
Any objection, Ms. Roberts?
No objection.
You are excused. You can leave that right on the table.